Recovering the authority of public institutions consists of two parts. In the first, there is a study on the drift of Sri Lanka from a rule of law system to a non-rule of law system. It studies the loss of the supremacy of the law, where the paradigm has shifted from a system recognizing the separation of powers to one based on the absolute power of the executive president. Under the new situation, the military has become an arbiter on national issues. This has involved changes in law, changes of investigations into crimes and human rights abuses, the loss of the binding character of the law, the loss of the prestige of the Constitution as the paramount law, and the loss of respect for treaty obligations, as well as the weakening of the investigative mechanisms, the undermining of the prosecutorial system of the Attorney General's Department, and impunity eating away at fair trial and the judiciary. The next change is a point-by-point review of the government actions, or should we say inactions, regarding the recommendations made by several UN agencies. It is followed by a chapter on 5 overlapping conflicts and their implications on the Sri Lankan legal system. A detailed study of the issue of torture and the failures in prevention is studied together with a praxis perspective on subverted justice and the breakdown of the law in the country. The problem of police reform initiatives within a dysfunctional system is studied in a separate chapter. The second part of the book consists of the study of 200 complaints about torture out of about 1,000, researched for the purpose of this book. The overall conclusion is summed up in the back page of the book thus. This book makes a shocking revelation. It confirms that all those who suffer human rights abuses face the same fate that the assassinated journalist Lasantha Wickramatunge predicted for himself in addressing the President of Sri Lanka. As he wrote, "In the wake of my death, I know you will make all the usual sanctimonious noises and call upon the police to hold a swift and thorough inquiry. But like all the inquiries you have ordered in the past, nothing will come of this one, too." The book is the product of nearly 15 years of work of many persons. Literally thousands of persons were interviewed, and hundreds of cases were pursued over the course of several years. This journey took us to the magistrates' courts, high courts, the Court of Appeals, the Supreme Court, and on some occasions, the United Nations Human Rights Committee. On all these occasions, we had the opportunity to observe how the government of Sri Lanka and its agencies acted in the face of the serious complaints raised in these cases. The basis of this book is the detailed records of these cases. 200 cases of police torture, mostly from the south, have been summarized here. During most of this period, parts of the north and east were not under the control of the government of Sri Lanka. However, these cases are from the areas under government control and from places far away from the conflict. Therefore, they speak of a far greater crisis of the Sri Lankan political and legal system than the ethnic conflict. For many years, the AHRC has commented on the crisis of the rule of law system in Sri Lanka, and these views have been shared with a large audience for a considerable time. The analysis of the problem has found the agreement of almost everyone, except those who are professionally obliged to deny that human rights violations exist in the country. No part of this book can be said to be an exaggeration. Perhaps, on the other hand, it may be justified to say that these revelations are, in fact, an understatement of the actual situation. However, this book is not just about Sri Lanka. It is a case study of one country that demonstrates the situation of many other countries in which the basic rule of law is fundamentally flawed. In Asia, with differing degrees of similarity, are the following countries: Bangladesh, Burma, Cambodia, China, India, Indonesia, Pakistan, Philippines, Sri Lanka, and Thailand. Many countries in Africa and South America would fall under similar situations. The countries in the Middle East have also the same institutional problems, but perhaps for different reasons. However, in-depth studies into the overall impact in the flaws of the rule of law in human rights, and particularly due process rights, have not received much attention. Most reporting on such matters is confined to condemning particular violations and sometimes making suggestions to remedy these, rather than to look at the total picture within which all the rights are undermined. The judiciary has to work within this total context. While the statutes may give them various powers and even recognize their independence, in the actual working, they can have no such independence. In fact, even when there are competent and independent judges, they cannot but fall victim to this total situation. They are merely persons trying to swim against the current, which is far more powerful than they. Unfortunately, such efforts to appear independent may only create a false illusion of the possibility of justice, when in fact such possibility does not exist. It is within that context that the place and the role of the legal profession need to be looked into. When the total system has collapsed, what can the lawyers do? A part of the profession may decide to adjust to the situation and thereby compromise themselves with unprofessional practices of dispute settlement outside the framework of the rule of law. Others may suffer silently, and a few may try to fight back. The few that do try to fight are often exposed to serious danger. Such is the reality that the global legal profession as a whole needs to understand if they are to contribute to the betterment of rule of law situations in countries like Sri Lanka, and also to assist in the efforts to sustain the independence of the judiciary and the dignity of the legal profession. This book also provides case studies of 200 torture incidents. All the cases are those for which efforts have been made for many years to find redress. In all instances, these efforts have failed. That is no surprise. Where a rule of law system so seriously fails, it is not possible to safeguard any of the rights recognized in the International Covenant on Civil and Political Rights. Human rights efforts often become artificial when in such efforts no real attempt is made to address the overall rule of law issue. Mere pressure on governments to investigate torture can have little impact when the total system of criminal investigations suffers from serious failures. Authentic attempts to improve human rights require new strategies that take into consideration measures to address failures of the rule of law.